in your name. It would protect you for the period of 20 years when you have registered a patent. That is so important, right? So now onwards, from today onwards, I'm seeing some other mic. So the organizer could help me to mute the other. Okay. So please show the attitude of registering your intangible asset than idea from today onwards as the value of, or I would say that to create a better value in the days to come as to that of your tangible asset. So this particular the tabular column would describe you the kind of the period that we would get when we are registering our different components of an IPR. An IPR, it is going to be a patent, it is going to be industrial design, it is going to be a copyright or trademark. The patent, you all know that it's a functional aspect for the 20 years time period that you would get the monopoly right. And for the design, it is for the first 5 years, and every 5 years that you have to renewal it. For the copyright, the lifetime period of the creator after his lifetime 60 years thereafter. Trademark, it is for the 10 years. For each 10 year, you have to submit the renewal for that. In my first slide, the tangible and an intangible asset, I made a very humble request. Then attitude of registering the intangible asset, it should be similar to that of the tangible asset. Then you all would ask me why I have to promote, why I have to protect the intellectual property, why I have to do that, sir. If I have registered a vehicle, I would understand. So I am creating a record that I am the sole owner for this vehicle. If I register a home or if I register a land, I could understand that why I have to do that. It's all very simple. So what is the purpose that you are asking me to register my intangible asset, an idea? Please consider these points. It would protect the rights of owners from the competitors. Imagine you have an idea now, which has the commercial potential, commercial value, and you understand the commercial potential behind that idea. Then what you did, you create a manufacturing facility, you started to manufacture the particular product, and you spend all your money, energy, time, everything in transmuting that idea into an end product, and you are releasing that end product into the market. Now your competitor, they are seeing the product, it is available in the market, and they are looking at the product, they understand the commercial potential of that particular product. What they can do, they also can create a similar manufacturing facility. They also involved in the manufacturing of your product in their manufacturing facility, and they also can release the product into the market. The releasing of the product, of course, much more lesser than the price of yours, because for your unit price, it's going to be involved with an R&D expenditure, because you created from the scratch. Then very obviously your unit price might be included with the R&D expenditure. For an example, 100 rupees. But for him, you have given everything. Then his price, it is going to be, for an example, 75 rupees. You cannot bring down your unit price to match with the 75 rupees because you cannot afford it. The real meaning is, when you have not included the R&D expenditure, that you are going to be the loser. then very obviously your per unit price, it is going to be the same that of the 100 rupees, and your competitor with the same product, so he is selling in the market 75 rupees. So there is no honest and genuine customer. The customer, of course, they would buy the product whoever they are selling very cheaply. So the loss is inevitable for you. Imagine in the same situation, you got an idea, you got the protection, the pattern I am talking about. Then later you start at a manufacturing facility, you are spending your time, energy, money and everything. Now the competitor, not only from India, any part of the world, not only your full product, any modules in your product, when they are trying to copy it down, then you can file the litigation case against them because they have infringed your patent rights. So with this example, we could understand that the rights of the protection of the owner, it makes a very great or significant difference. It would recoup research and development cost. Whatever the research and development cost that you are going to put in, that you can get it back because you got the protection. No one can copy your the invention that you have created. It would encourage the innovations. There are number of innovations that we are all seeing, right? Even the people are saying about within a period of 10 or 20 years down the line, even in our shopping mall, some other the shopping mall, we are going to see the bio-organ shops. So that the moment that you can visit those bio-organ shop and you can get some kind of the organ, for an example, skin or some other the body parts, and you can identify the doctors with whom that you can fix it. So even Elon Musk, in a very recent interview, he was telling about his point of interest, more than electric vehicle, it is going to be a robotics. So when we are talking about these innovation, the company, the corporates, and all other the sector, they are contributing for the better the lifestyle or the better the life advancement. Then the key aspect is why they are doing it. Because they all understand that the innovation they are involving with, when it create an outcome, a product, for that product they would get the protection. So the important thing that we could learn from here, as a student, as a faculty, we all have to contribute on the innovation thinking, the innovation, the development, the product development. Eventually that we have to get the protection for all those inventions that we are all making. For those inventions, of course, we would get the protection. Those protection, it would make us to feel very comfortable in the days to come. It would give you the monopoly right, because that you are ready to disclose your the invention that you have made. It would provide you the revenue stream. It can be licensed or sold. All the time you need not to think about that I need to establish a startup. I cannot, that is not my policy or something. No need to worry about it. If you want to earn the money from your own patent, either you can create your own startup or you can identify the company for the possible technology transfer. It would protect your investment. It would drive the economic growth, competitiveness. It would create and support job. The picture that you are all seeing that I have taken from the internet source. You please consider the third picture. Without real estate law, land would not exist. What does it mean? Without real estate law, land would not exist. For an example, if there is no real estate law, it is existing in our country. It means whenever that I purchase a home, the next day anyone can encroach it. Anyone can occupy it. Because there is no existence of real estate law. We cannot own any land or home. But what is happening right now? We all understand that the real estate is the best of the kind of the investment the strategy that anyone can follow, because we all know that there is an existence of real estate law. Similarly, you all have to believe that there is an existence of patent law. So very obviously that you all can involve in the different kind of the innovations, and you can create the product out of it, and for all those products that you would get the protection, and that protection would give you the much more the revenue in the days to come. Think in that aspect. Then subsequently that you would ask me, okay sir, we understand there is a necessity of protecting our idea. Okay, the patent. Good, very good. Then would you explain us as a student, as a faculty, how we could get the profit from an idea? Is it possible for a student, is it possible for a faculty would get the profit from an idea? Of course, for the faculty, it is going to be a secondary income. For the student, it is going to be the best of their technical career growth. Then, as an individual, how I could get the profit? Consider all these points. The very foremost thing is, we have to analyze, is there a market for an idea? Can I exploit the market directly or via a license? To explain this, I would recall a case study that recently that we have done it with one student entrepreneur. This student, this group of students, they approached us, our company, to file a patent. And that one is the simple gas burner, so efficient gas burner, and we got them the patent protection. After that, we inquired, so what is your idea about this efficient gas burner? And they were telling that, sir, we do not have any manufacturing the facility. We cannot manufacture this gas burner. Then we advised them, why don't you identify some other the gas manufacturing company are there in the town, so that you can invite them for the presentation in our office. And they invited some of the gas manufacturing company, and we facilitated the movement. And some company who came forward the presentation, and one company they showed the interest. And the students, they registered the company and they transferred the technology to the gas manufacturing company. Now the student, they are getting the money, whatever the product the gas manufacturing company they are selling in the market, and they are getting some profit out of it. Do you know what these students doing now? They are not into manufacturing of any other subsequent product, even though they filed a good number of patents for their company. They are identifying the problems are existing with the society and the industry. They are identifying the problems are existing with the society and the industry, and they are finding some optimum solution for that. And for those solutions, they are filing the patent. Now they are approaching the companies, the relevant companies, for the possible technology transfer, and for some other the patents, they got the success too. Only they have been involved on the R&D, research and development, not on the manufacturing. That also possible. In this an example, how the student earned the money, they have not created the startup for manufacturing the product. Instead, they identify the relevant company and they made the technology transfer, and they are getting the royalty. We have supported the other set of students. For an example, one such a student group, they created one application programming interface, mobile app, and we got the protection for them. And after that, because from our company, not only that we are filing a patent, also we are helping the student, faculty, and the startup company to commercialize their patent. And we inquired about, so what is their next idea? then they were telling that, so we were clueless, and we advised them for this mobile app, of course, does not require any kind of the investment, the huge investment. Why don't you start a company, and why don't you develop it, and why don't you introduce yourself into the market? And they did that. So even that app, it is available in the Google Play Store as well as in iOS. The lesson that we are learning from these two examples, it is an inventor who can decide either to get the profit, either they wanted to establish their own startup, or identifying the relevant company for the possible technology transfer. You keep those students' place, that you are there in the student's place. You also can think about. Only thing is the creative thinking. If you are able to think so creatively, you also can think about lot of inventions, and you can create those innovations. And for those innovations that you can think about, either a company of your own or identification of some company for the possible technology transfer. Eventually, the point here is, for your creating thinking, of course, it would help you to earn more. That is so important. Second one, is it likely that a competitor arrives at the same idea? For this, to understand this particular the statement, I would like to give you an example of cricket stump attached with an LED arrangement. This inventions, the cricket stump attached with an LED arrangement, you all would have seen that in all the cricket matches, the moment Bales comes out, an LED will be illuminated, right? So this particular the invention filed by one Australian cricket stump manufacturing company. That company has filed this patent in more than 85 cricket playing countries. Do you know the cost of this stump? Even one of the recent IPL matches, the Hardik Pandya broke one stump, right? So he threw the ball and it hit, and it broke the stump. The next day, you all would have seen it in the newspaper. The BCCI paid the penalty of 40 lakhs rupees to the company. Do you know the cost of this stump? That you cannot buy this stump. No one can buy this stump. Instead, you can use the stump for one-day match. So for an example, today if I do convene a match, then I have to get seven stump one set from the particular the company by paying 25 lakhs for one-day match, one match, seven stump set, 25 lakhs. If you have considered a mobile phone, there are hundreds of manufacturers in the market. If you take a laptop, there are hundreds of manufacturers. If you take any electrical or electronic, yes, small appliance, without the patent, no company, they would release their product into the market. Any product, you take any product, without patent, no company would try to sell their product into the market. And very obviously, for the cricket stump also, it has been filed for the patent. Do you know, across the globe, throughout the world, there is no competitor for this cricket stump attached with an LED arrangement. There is no competitor. Only one company in the world. Do you know the reason for that? Why there is no competitor for this simple apparatus? This particular the stump might be having the component as one circuit closer, right? The principle is circuit closer and opening. The moment circuit open, the light, it has to be illuminated. When the circuit closed, the light it should be switched off. That might be the thing. So why there is no competitor? The reason is, in one of their claims, the cricket manufacturing company, the stump manufacturing company, they mention The LED illumination will be performed within 1,000th second. If you and me would able to make a better stamp than this 1,000th second, the throughput, 1,000th 1 second, you and me also can file a new patent. We also can go for the new patent. We also can market that the item into the market. But no company, even till then today, they were able to make a better stamp with a better performance, and they were not able to release their product into the market. So the lesson that we could learn from this case study, from this an example, as an inventor, as an entrepreneur, as a startup creator, we also have to prevent our competitor to come to the market with a better product than us for a period of 1 or 2 years. If that is the case, then we could get the profit like anything. Are licenses of other ideas, patents required to commercialize your invention? For an example, imagine that you are standing before a wash basin. Hope you would understand. You are standing before a wash basin. That wash basin is hydraulic lever attached wash basin. The moment that you are going nearer to the wash basin, it has to calculate your height, and the height of the wash basin, it has to be matched with. The moment a small kid of 1.5 feet or 2 feet, when she or he goes nearer to the wash basin, the height of the wash basin, it has to be scaled down. This is the invention that you have done. And very obviously, this is a very nice invention that you would get the patent. But before you are releasing this product into the market, you have to be so sure you are getting the license from the patent holder for the wash basin, because your product, which it has been attached with an existing wash basin, that you cannot sell the product individually. You have to attach your the hydraulic lever arrangement into that existing wash basin, then only that you can sell the product. So very obviously, the wash basin, that you are not owning the patent for the wash basin, only for the hydraulic lever arrangement. So before you release your product into the market, you have to obtain the license from the wash basin, the patent holder for the wash basin. In patent, there are two aspects. One is, you should never allow any other person to copy your products. Another one, you should never copy any other person's patent in your product. For our simple understanding, you should never trespass into any other person's property or land. Similarly, you should never allow any other person to trespass into your property or land. If you are doing this, that you are not venturing into any other's property, similarly, you are not allowing any other person to come or to enter into your premises, then very obviously you can get your profit. Is it easy to reverse engineer? I do not know how many of you are well versed with the Raspberry Pi, Arduino, or some other the trademark the development boards, because the student used to demonstrate their the POC with this kind of the board. But we would advise to the startup, the owner, the startup, the company owner, not to have any trademarked items in their patentable invention, because what would happen when they are selling the product into the market? The moment the competitor comes to know, oh, this is an IC chip. Oh, this IC chip, of course, the data sheet that I could understand. Oh, here the input lines are there. Here the power units are there, and here the computational unit. Okay, everything that I could understand, that I could recreate everything. This may be possible, right? In order to prevent that kind of the reverse engineering aspect, what advice that we would give to the startup owner, instead of having a known IC chip, they have to go with some ASIC, application specific integrated circuits, so that they can prevent the competitor to read about any kind of an IC, right? So please keep it in your mind. Is it easy to design around it? For an example, you have built a data acquisition board. Data acquisition board means you would be having a sensor, signal conditioning, and microcontroller and an actuation element. In this invention, you have had all other wired interfaces. You have used USB, you have serial port, you have parallel port, and you have RJ45, every all other the wired interfaces that you have described in your product. But unfortunately that you have not mentioned anything about the wireless interfaces. What your competitor can do means, by simply replacing wired interfaces with the wireless interfaces, they can file a new patent. You cannot do anything. Why? In your patent that you never mentioned anything about the wireless interfaces. Instead of what you should have done that at the time of filing a patent itself. My invention, it would work similarly even with the wireless interfaces in the same order. If you have added this sentence in your patent, so the competitor, they cannot come up with a better product with the wireless interfaces than yours. So you have to prevent your competitor to design around your invention, your product that you have built. Hope you would understand, hope you would get my point, right? So keep that thing in your mind in order to get the best of best profit from your idea from the market. Will it be easy to identify the violation of patent rights? If any other person, not only from India, some part of the world, they are trying to copy my product, what I would do, how I would track that, how I could identify there is a violation, there is an infringement, it happened. That's kind of an exercise you have to keep again and again. If you are a startup entrepreneur, and are you ready to invest time and financial resources for enforcing your patent? When you come to know that, so the some person, some company, they are copying your product, how you are going to enforce your patent right? How you are going to do that? What is the kind of an exercise that you are going to make? If you are able to follow all these points, irrespective of the kind of an individual that you are, you might be a student, you might be a faculty, but you would get the profit out of it. I know most of my students, right? So whoever the people, they filed the patent, of course they got the profit. Even myself, of course, I registered 2 companies. Of course, I am owning 2 companies. Of course, I am getting the product, the benefit from by following these rules. If it is possible for me as well as my student, of course, it is possible for you to believe on you. So you have to believe on you, then you can create your own, then it's a kind of an empire from your idea that is there in your mind. So whenever I used to go and giving this kind of the lecturing, I would get 2 different kind of the context. One is the student, they would tell me, sir, I am a student, sir. I am just learning everything. So what I would do, how I could file the patent and how I would emerge myself into the startup. It is not possible for me. Other set of the comment that I would receive from the faculty people, they would say me, sir, I am a 40 plus, or I am a 30 plus, or I am a 50 plus. Hereafter, what I am going to do after filing a patent, then is it not possible for me, sir? For filing a patent, to emerge or to venture into the market, the age is not a constraint. You take inspiration from Visalini, 6 years old kid. She has filed the patent. She got the grant for her patent, and she is now venturing into the startup. So her product, and she is a 14 years old girl from Kerala. and she has invented this particular the machine, the washing machine come exercise machine. So age is not very biggest constraint, only our attitude and our the thinking. Then whenever I used to visit the number of the tier 3 or tier 2 institute, they were telling me that, sir, if at all that I'm in IIT, if at all that I'm in NITs, then I would have done this, I would have done that. Believe me, it is not about the resource, it is mostly about an individual who has that resource. If I speak very in a very simple language, it is not about the tool, it is about the individual who utilizes the tool. If I know how the particular the tool it has to be utilized very properly, then I would bring the profit from the tool. If I do not know anything about the tool, right? So very obviously I cannot do anything with the tool. You take these an example. Of course, not only these the picture that I am showing you. You just visit. You just type in the Google Indian Jugaad. You would see number of YouTube videos. You would see number of articles. Our fellow Indian citizen, how innovatively they were utilizing the resources are there within their environment, and they were made use of it, right? So it's all very inspirational story that you would get. One of the very important, this one is so interesting to me, and it's a very simple water bottle. It's that too very used water bottle, and the inventor, they made one very intelligent irrigation system. With this irrigation system, not only he saved the water, of course his time and energy. So he does not, of course, does not bother about anything on how he has to irrigate all those kind of the thing. Instead, what he has to do means he has to fill it up this bottle, and he can the control the flow, because this is an IV tube, right? Intravenous tube, and the saline the tube, and very obviously he can preset the kind of the droplets it has to be passed on into this the flow, the pipe. Think about that, right? It is about our thinking would make a very difference. Of course, not the resources. I do not know how many of you are participating in Smart India Hackathon. The Smart India Hackathon, of course, it is not new to India. Even 1929, there were one call from our Mahatma Gandhi ji, and he was making this announcement to have the spinning wheel of the better effectiveness. And even he introduced, he was telling that the prize money of this event 1 lakh rupees in the year 1929. Even of course, what impressed me so much, of course, this particular the line. If in case the machine satisfy the criteria mentioned, then the inventor designer can patent it on his name to protect the rights on them. But if they wish to become eligible to win the prize money 1 lakh rupees or the contest, then the designer have to transfer the rights of the patent to Indian Chakra Sangh Council. So it is so interesting. You please, whenever your time permits, you visit this webpage. Still, they are keeping this announcement what Gandhiji he made that particular the time to have the better the spinning wheel, right? So this, of course, our student they created. Even I wanted to show you this particular the sentence they made the interview in Times of India. We have patented an idea. Even we recently made a technology transfer with the NACL, Nagarjuna Fertilizer, Hyderabad-based company, and they came forward to have the container for their urea, the fertilizers. And we did that, and we filed another one joint patent exclusively for the urea containers. So how that would be so possible means because of the pattern. Imagine there is no pattern. The student, they have given all their an idea in the newspaper article. It is available in the public domain. So the company, the moment they are reading, they also would get an idea and they also would make the container material without intervention of the student because it is available in the public domain. But the moment the student, they were claiming that they got the patent, so all other the people, whoever the people they wanted to copy it, they were so the careful, they would show some kind of the careful because the idea, it has been protected. So without these student the permission, the license, if the any company they have created such a container, the students, they can file the litigation case against them. So we got number of interest from the companies. Of course, today that we made a technology transfer with the NACL. So that would be possible because all our students, they have been participating in number of the idea competition, number of the hackathon kind of an event. But the institute, it is not getting the benefit out of it. Instead, what we could do means whenever our student, they are going for that kind of the competition, we have to understand the patentability aspect of those ideas, what our students, they are proposing. If it is possible, then we have to help the student to file their patent. So the most importantly, not only the student would show kind of the comfort and the confidence in demonstrating that idea, also the institute as well as the student jointly, they would get the profit out of it. Think in that aspect. So some of the common mistakes we inventors, we are making as per um, European Union Patent Office. So you are seeing two characters here. The two characters, they are holding the same apparatus. This apparatus, of course, the nut cracking machine, and this very complicated one also, it does the same purpose, nut cracking. As a customer, which model would you like to prefer? Of course, very simple model. So as an inventor, we have to think how we could create a solution in a very simple manner so that we could market the product in a much more the simpler manner. This fellow, he has not understood the problem fully and he wanted to open two bottles, then it is not possible for him. This fellow, he is holding a wheel, it is not new, and this fellow, he is not maintaining his secret and he is disclosing the content with everyone. In patent, maintaining of secrecy is so important. This fellow, he has had some kind of the thing, but no one would prefer to have it. This fellow does not know the real value of his product, so very obviously he cannot so successful in the market. So then, what is a patent? Patent is an exclusive right. Through an exclusive right, you can make it, you can use it, you can sell it, you can import it, you can transfer it for the period of 20 years. Once the period ends, the 20-year period ends, it comes to the public domain. Anyone can make it, use it, sell it, transfer and import it. The patent is territorial in nature. When you have a patent protection in India, you can do your business only in India. Imagine that you got the patent protection in US. With that patent protection, that you cannot do your business in India. Similarly, you got the patent protection in India, you come to know that someone in Australia or China, they are misusing your patent. You cannot do anything unless otherwise that you filed the patent in Australia and China, because the patent is territorial in nature. The patent is for any field of technology. So you might be from computer science, information or technology or some other. So any field of technology, even chemical, biochemical, pharmaceutical, biotechnology, any field of technology, of course, it can go for its patent protection. It is a simple contract. You are ready to disclose the content with the public. You also would have known about the Coca-Cola and the KFC. These two recipes, of course, even after the period of 5 decades, 6 decades, of course, it is not been disclosed in public, and the company, they have decided to go with the trade secret. When it is under the trade secret, the company need not to spell it out in the public and they have to maintain their secret. But in the patent, it is not in that way. You have to disclose the content in the public. In turn, the patent office gives you the protection. So patent, it could be a product, it could be for an apparatus, it could be for the device, it could be for the process, it could be for the method, composition of matter, either new or improvement of the existing. So why it is so important? In all my case studies, you would have seen that the student, they got the protection, then only the company, they came forward the technology transfer. When the company does know about the student, they have not made any patent, only a journal publication or the conference. The moment the company does know about it is already available in the market, already available in the public domain in the form of journal paper or the conference paper, then they would not come forward for any negotiation, any technology transfer agreement, because it isn't available in the public. They also can copy the content there in the public. But the patent is a very different aspect. The moment the company, they come to know that you got the patent protection, they cannot simply misuse your patent. They cannot simply infringe your patent, right? So they would come forward for the possible negotiation and the technology transfer. So what the patent office would look at? So how the patent are being granted, right? So the patent office in all our pages in our application, they would consider only 3 criteria: novelty, inventiveness, industrial application. Throughout our document, the patent office would consider or would evaluate your patent application in terms of novelty, inventiveness, industrial application. Novelty would be seen from the perspective of the document's availability with the public domain. For an example, imagine that I am standing before you, that I am showing you my pen. Then I am asking you what this object is. The moment that you are all seeing the pen, that you all would say that, sir, this is a pen. That is how that you would answer me. So the moment that you are seeing the pen, that the object that I am showing, you would easily recall, sir, this is a pen. This is how the patent office also would ascertain the novelty. Imagine the particular object that I am showing that you have never seen in your life. The moment that I am showing such an object, then after seeing that object, that you would ask me, sir, we have never seen this object in our lifetime. What is this object? Because any object, it has been stored in your brain, it would be compared with a real-time image, and when the comparison, when it has yielded the similarity, you would say this as a pen, this as a object. If the pattern, it has not been stored in your brain, that you have never heard about it, then you would say the word new. Sir, this looks new to me. For the patent office also, in order to ascertain the novelty, they would compare whatever the application that we are submitting before them. It would be compared with an existing document from the period 1911. When that similarity checking, that comparison has not yielded any similarity, then the patent office would clarify as, yes, we have verified with all other the back records, the literature review. We come to know that your document does have that novelty. Hope you would understand, right? So the second one is the inventiveness. Inventiveness would be seen from the perspective of the person known in the art. Imagine that you wanted to buy a chair attached to an umbrella. Then you were searching in the Amazon, the Flipkart, in all other the market space. You were able to get either chair or the umbrella, but not chair attached to an umbrella. Then what the novelty part it says about, whenever there is unavailability of such a record, then you can go for the pattern. Then what you did, you created a record, chair attached to an umbrella. Then you are submitting before the patent office. The patent office also comparing with the existing document, they also would come to know that there is an existence of either chair or the umbrella, but not chair attached to an umbrella. Then they also clarified you, yes, it has the novelty, but The second criteria is inventiveness. Inventiveness would be seen from the perspective of the person known in the art. Who here the person known in the art? Any person does know something about the chair or the umbrella, they all would understand that how these two objects can be attached together. Either they can use simple thread or they can use some kind of the welding mechanism so that they can bring these two objects combined together. So the patent office would clarify, even though your application does have the novelty, it is not having inventiveness because anyone can do. It is not only the inventor who has brought an application. He only have to do that. Instead of any person does know about the chair and the umbrella, they all can understand how these two objects can be interfaced together. Industrial application, either you have to mention in your application how your invention it can be manufactured by an industry, or how an industry can use your invention for their manufacturing. Either your invention has to be manufactured by an industry or it has to be used by an industry for their manufacturing. Then you have to mention in your record how far it is going to be useful for the society. So let me remind you once again, there are only 3 criteria. Based on that only, the patent office would either reject your patent or would give you the grant to your invention. Novelty, inventiveness, industrial application. In the same time, you also have to understand there are some other inventions, some other than experiments, some other the project works we all have been involving with that won't be considered as a patentable invention at all. That won't be considered as a patentable invention. We also have to ensure that whether our project work would fall under the category of non-patentable invention or not. In Indian Patents Act 1970, Section 3 and 4 described about non-patentable invention. Any invention against the natural law, because some people they would claim that their instrument, their system can produce more than 100% of performance. It is not possible. And you all have understood about the law of energy. The energy, it cannot be destroyed or it cannot be created. One form of energy, it can be converted into another form. When you are looking at these two apparatus, you all would presume that, oh, for these two apparatus, it won't require any input energy, but it would work for some span of time. But it is against the natural law, right? So any gambling machine, any gun related thing, which would affect the morality of the public order, which cannot be considered as a patentable invention. Mere discovery of scientific principle, for an example, anyone who wanted to prove the Ohm's law, the existence of the Ohm's law, it is not patentable. Or any inventor have identified new characteristics from the known substance, for an example, turmeric powder. We all know that the properties of the turmeric powder, if the biochemist, the person who identify new characteristics from the existing turmeric powder, it is not patentable because the turmeric powder is an existing, even though he identified new characteristics, it is not patentable. Similarly, mere admixture of two known substances. That fellow, what he did, he added the turmeric powder with the chili powder, and he had made the new product out of it, right? As an outcome, it is not patentable. Why it is so? Because the turmeric powder is a known substance. Chili powder is a known substance. When he is mixing these two known substances, it is not patentable. Mere arrangement, rearrangement of known devices. I was telling you about the chair attached to an umbrella or the pen attached to an eraser, because we all know that the pencil attached to an eraser. One person, he wanted to replace the pencil with a pen attached to an eraser. Anyone can do that. Whoever the people, they all have seen pencil attached to an eraser, they all would understand that how the pencil can be replaced with a pen. So it does not have any inventiveness. Method of agriculture or the horticulture, agricultural instruments are patentable, but not the method of agriculture or the horticulture. Similarly, biomedical instruments are patentable, but the surgical procedures are not patentable. Plant or animal, whole or part, it is not patentable. Mathematical model, business method, or the computer programs, or then algorithms are not patentable, but it can be registered under copyright. Literary work, dramatic work, artistic work can be registered under the copyright, but it would never be considered as a patentable invention. Performing mental act. You all understand how unique the Bumrah's bowling action. If he wants to file a patent for his unique bowling action, it is not patentable. Presentation of materials, this presentation slide can be registered under copyright, but the presentation of information, it is not patentable. Topography of integrated circuits in India, it is not patentable. Traditional knowledge. For an example, 3 months before, I do not know whether you have read from the newspaper or not, there were dispute, it happened between Gujarat potato farmers versus Pepsi and Co. Pepsi and Co, the Lay's chips, right? You all understand, you all know that. The Pepsi and Co, they got the patent for one particular, the potato variety for their Lay's chips manufacturing. After that, they issued the notice to all the Gujarat farmer. Thereafter, the potato variety should not be cultivated by any other the potato farmer. But what the potato farmer, they did, they filed the case in the High Court, the Gujarat High Court, and they were telling that the potato variety, it is not patentable because they already cultivated the potato variety. So after seeing all the evidences from the both parties, the High Court awarded the judgment as the Gujarat farmer, this the potato variety, it is the traditional knowledge, and the Pepsi and Co cannot own this patent. Similarly, in 1996-97, one US-based company, they filed the patent for our neem and turmeric. And after that, they issued the notice to all our Indian medicine manufacturer. We cannot use the neem and turmeric in our medicines without obtaining the license from them. After that, our Indian government, they showed our the palm script and all other the evidence from the historic period. We all Indian know about the medicinal property and the characteristics of neem and turmeric, and the Indian government, they got the rights back to use neem and turmeric. This would be possible because of the existence of these law, section number 3P, the traditional knowledge. Similarly, any atomic materials, atomic related the thing, it is not patentable. So very obviously this would happen. Even sometime the startup owner during our discussion, they were telling that, sir, we really do not know whether we would impress the investors. And what we would try to do means today we do have a session with an investor. We make a presentation. If the investor, if he is okay, then the tomorrow we come for the patent protection. Then we would ask them, okay, everything is okay for in your statement, but what would happen? Your investor, he is disclosing the content with someone else without your knowledge, because you cannot prevent him, right? You made a presentation and now you are disclosing your idea. Then it is not he is going to copy your product. Instead, he would disclose the content with someone else. So you are disclosing the content, very obviously the secrecy that you are not maintaining. Some people, they may copy your idea. So please careful about that. Similarly, that you can trust the patent office. Section number 75 of Indian Patents Act 1970. The employees of the patent office, they cannot own, they cannot file a patent. So very obviously that you can trust the patent office and you can disclose the content with them. Before filing, ensure that there were no publication, there were no sale of product, there were no lecture or presentation. It has been done pertinent to the invention for which that you are seeking the patent protection. So when to file? On day one itself. For an example, today you got an idea. So today is the best day to get your protection. Even not on tomorrow, not on day after tomorrow. Today itself that you have to file your patent. Where to file? Of course, we have the branch offices in Chennai, Mumbai, New Delhi, and we have the head office in Kolkata. So either we can visit in person and we can submit the hard copy of our patent document, or otherwise we can visit this web page ipindianic.in, and we can create our login credentials, username and password. It's a free of cost, and we can upload all our document, right? So filing a patent application, natural person, an individual, startup company, or an educational institute. If you are filing through your educational institute, of course, you have to pay only 1,600 rupees. For the publication, 2,500 rupees, natural person, startup company, and an educational institute. For request for the examination, it's a mandatory 4,000 rupees for the natural person, individual, startup company, and the educational institute. I do not know the existence of the Kabila scheme in your institute. Through this Kabila scheme, the AICTE will reimburse you this 4,000 rupees, and the filing charge is 1,600 rupees. For one patent, they will reimburse you 5,600 rupees, and for 10 patents that you can get the reimbursement of 56,000. So the faculty, they can take the steps to register the Kabila scheme for your institute. So you would get the benefit of filing 10 patents and all other than ARIA ranking and the NIRF, everything, and even you can create some kind of an IP asset. Through that IP asset that you can get the benefit out of it. This is the patent filing procedure. I told you earlier, on day one itself, the moment that you get an idea, and that day itself that you have to get the patent protection. But very obviously on day one itself that you might not be having any result or the methodology or any other the modules, right? Only the concept, only the idea. So in order to get the protection for your concept or an idea, you can file it through provisional specification. Within a period of 12 months after filing the provisional specification, you have to file your complete specification. If it is not, earlier filed provisional specification will be considered as an abandoned. Or day one itself, you have all the results, methodologies, illustration, everything in your hand. You can file the complete specification. Your document will be appeared in the patent journal. If you do not want to wait for this 18 months time period, you can submit form number 9, request for the early publication, by paying the prescribed fee of 2,500 rupees. All your document will be appeared in the patent journal within a period of 7 days, not more than 30 days. Within a period of 48 months, you have to submit form number 18, request for the examination with the prescribed fee within a period of 48 months from the initial filing. Your document will be examined. They would issue the first examination report. Within a period of 6 months, you have to submit the response to this first examination report. They would call you for the hearing either in person to the patent office or otherwise through the video conferencing mode. Within a period of 3 months after the hearing process has been completed, either they would issue the grant certificate or the refusal order. So this is an exact patent filing procedure being followed in Indian Patent Office. Provisional specification on day one, within a period of 12 months, you have to submit the complete, or otherwise earlier filed provisional specification will be considered as a abandoned, or on day one itself that you can file the complete specification. Within a period of 18 months, all your document will be appeared in the patent journal or otherwise you can submit the form number 9 at the time of filing your complete specification. Within a period of 7 days or not more than 30 days, your document will be appeared in the patent journal. Within a period of 48 months, you have to submit form number 18, request for an examination. Your document will be examined. They would issue the first examination report. Within a period of 6 months, you have to submit the response to the FER, first examination report. And they would invite you for the hearing process, either in person or the video conferencing mode. Within a period of 3 months, they would issue the grant certificate or the refusal order. So the documents required to submit your patent: form number 1, application for grant of patent, either complete or the provisional in form number 2, statement and undertaking. It means that as a resident of India, I would not file a similar patent in a foreign country without obtaining the license, without informing the patent office. That kind of an undertaking that you are giving to the patent office in form number 3. Power of attorney: when you have the patent agent and the patent attorney to process all your files, then you are giving the power to him through this form number 26. Declaration of inventorship: you are narrating who are all the applicant, who are all the inventor, and the form, the rightful form it has to be submitted is form number 5. Request for an examination, form number 18. Illustration and the fee. What we would do means, today already it's 1.5 hours. In some other occasion, I would demonstrate you how you can fill up all these forms by yourself and how you can create the login, the credential, username and password in ipindia.nic.in, and how you can upload these documents into the web page, so that you could understand how you can prepare all these forms, how you can create your username and password, how you can upload all these forms into the web page. Everything as a practical demonstration we would try to see in some other occasion. So this is the patent filing procedure for the international patent. For an example, if you want to file a patent in USA or the China or some other Australia, you no need to visit the particular country. Instead, you can file the patent in Indian Patent Office by creating an ordinary application. Within a period of 12 months, you have to submit that application in WIPO, World Intellectual Property Organization. You can create username and password freely, so no restriction on that. After creation, that you have to upload your document, the PCT. Then, in a period of 30th month end, 31st month, you have to let our Indian Patent Office to understand which particular the country that you want to file a. You have to tell the Indian Patent Office that I wanted to file the patent in USA. Then all your application, it would be transferred to US Patent Office. Even you can file the patent in Hindi, not in English. Of course, even you can file the patent English. Of course, you can file. If you want to file the patent in Hindi, of course, you can file the patent in Hindi. The translation, everything, it would be carried out by the Indian Patent Office, and they would submit the patent, the application to the other country. So you no need to spend, or you no need to spend more, or you no need to have the patent attorney from the particular country. Instead, that you can file the patent, you can use the Patent Office services, Indian Patent Office service, then you can obtain the patent in any country. The conventional country, the people would say more than 185 countries the patent, similarly that you can file. So some of the faculty, most importantly, they are trying to file this Australian innovation patent. Please do not do that. Why I am telling you means, even in the certificate itself that you can read this statement, this innovation patent cannot be enforced. What does it mean? Even when your RC book, it carries the word, this RC book cannot be used as an evidence. cannot be used as a proof of that you are owning the vehicle. Would you mind to buy, or would you mind to get that RC book? Then you would ask to the RTO office, then what I would do with this an RC certificate. Similarly, any patent certificate, of course, it is a kind of that I am enforcing my patent rights, right? Then what I would this, it is not possible that I cannot enforce my patent rights with this certificate. Then what I would do with this certificate? I cannot show it for any NBA purpose. I cannot show it for any NIRF. I cannot show it for any then ARIA ranking or some other thinking, even appraisal. This won't be considered. Then what else that I would do with this certificate? I cannot do the business with this certificate. Then what I am going to do with this certificate? Please do not waste your money in obtaining this innovation category of patent. So most number of people, they are approaching me to help them to get this patent. But I told them very strictly, no. Even the section number 39 of Indian Patents Act 1970, not only Indian citizen, even residents of India cannot file a patent unless otherwise they are getting the no objection from the Indian Patent Office. We cannot file a patent in a foreign country without obtaining the permission from the Indian Patent Office. So please do not do that. So very obviously, and we started our discussion with a tangible and intangible asset. Then I made a very humble request to every one of you. You please show the attitude of registering your intangible asset. The similar manner how you are forcing yourself to get the protection for your tangible asset. Because of the value proposition, it is going to be the same order for your both tangible asset and intangible asset. Also that we have seen why we have to promote and the protect intellectual property. Also that I was narrating number of case studies, how we could get the profit from our intellectual property. Then we were trying to understand what the three criteria the patent office usually to follow to ascertain the patentability aspect: novelty, inventiveness, industrial application. Novelty, that I have given an example as the pen. In your brain, the pen image, it would be stored. The novelty would be seen from the perspective of the documents availability with the public domain. Inventiveness, that I have given you the example as chair attached to an umbrella. Inventiveness would be seen from the perspective of the person known in the art. Industrial application, either your invention, it has to be manufactured by an industry or it has to be used by an industry. So in your patent application, you have to make sure that you have added these three elements: novelty part, inventiveness part, industrial application part. Then you can confirm that you are going to get the grant certificate from the patent office. Also that we have seen section number 3 and section number 4 of Indian Patents Act 1970, which describe about non-patentable invention, right? Also that we have seen the forms are to be required to file your patent. And I was telling you that in some other occasion that I practically demonstrate how you can fill up all those forms and how you can upload all those forms into the IP India nic.in. Also that we have seen patent filing procedure, right? So if you have any questions on this topic, that you can ask me.
Thank you so much, sir, for spending your valuable time and sharing your knowledge with us. I request the participants to raise their questions or post your questions in the chat box. So someone posted a question here, like, why government is giving more weightage for design parents?
why government is giving more weightage for design patents? It is not the government, sir. Very obviously, it is the kind of the thing it is as. The design pattern, of course, even in no longer in NBA or only than ARIA, they have had one the component called the copyright or the design. But in most of the cases, the patents are so important. It is the pattern are so important, right? So please concentrate more on the design rather than the design pattern. It's a utility pattern. Any other questions?
Okay, so now it is participants are requested to fill the feedback form which is posted in chat box to get their certificates.